The High Court has declared as unlawful and unconstitutional a government directive banning public gatherings. This decision coming after President Uhuru Kenyatta announced a further extension of the existing COVID-19 protocols. Let's get more from our very own Chemutai Goin on the developments that have created confusion over COVID-19 containment measures.
As the COVID-19 pandemic continues to ravage the country, claiming lives, President Uhuru Kenyatta moved to escalate some of the containment measures. In the Public Order No. 5, the President noted that in the past 1 week, 18 counties had recorded a positivity rate of above 20%.
And over the last week, the following counties have recorded a positivity rate of above 30%. These are Kiambu, Nyandarua, Muranga, Makueni, Machakos, Baringo, Meru, and Nyeri.
And to contain the spread of the Delta variant of the virus, known to spread 20 times faster than the Alpha, Beta, and Theta, President Kenyatta announced the extension of the 10 p.m. to 4 a.m. curfew orders by another 60 days. Also, in-person meetings, public gatherings, and political gatherings were suspended for a further 60 days.
Recently evaluated reports have pointed to an exponential rise in infection rates across several counties, occasioned by unrestricted gatherings and congregations in breach of guidelines as issued by the Ministry of Health.
Though social gatherings such as weddings, traditional ceremonies and burials are permitted, the number of attendees is capped at 100. The President also directing the proprietors of funeral homes to adhere to the directive that burials be carried out within 96 hours of confirmation of death. In-person worship is allowed. Operations of bars and restaurants will continue in line with the Ministry of Health directives. However, the owners of any establishment defying the orders will face the law. But the President's directive coincided with the High Court ruling that has thrown confusion over some of the containment measures. Justice Anthony Mrima declaring the directives restricting and prohibiting public gatherings and meetings as unlawful and unconstitutional. The case was filed by the Law Society of Kenya. The court saying, and I quote, "A declaration be and is hereby issued that all the directives made by the National Security Advisory Committee on 7th October 2020 and ratified by Cabinet on 8th October 2020 for the use of Public Order Act Cap 56 of the laws of Kenya to contain, restrict and prohibit public gatherings, meetings and processions in the name of combating COVID-19 and containing the weaponization of public gatherings are unlawful, unconstitutional and in violation of Articles 10 subsection 2A and 245 2 subsection B and 4 of the Constitution for directing the law enforcement officers on how to discharge their duties." The judge further barring the Inspector General of Police, Hilary Mutyambai, from implementing the COVID-19 directives on meetings and public gatherings, saying an order of prohibition be and is hereby issued, restraining the Inspector General of Police, whether by himself or any police officer under his command, from taking directives from the National Security Advisory Committee. The government is yet to respond to the latest developments, which have left the fate of at least some of the containment measures in a limbo, especially at a time when politicians are already crisscrossing the country ahead of the elections next year. Chemutai Goin, Citizen TV.